call the meeting to order.
Thank you, Madam Chair. If it's okay with you, I'll go ahead and sort of take over to run the meeting.
Yes, that's fine with me.
Thank you. Okay, so the meeting has been called to order. The time is now 4:04 p.m. And I'm going to do a roll call. Chairs, Andrea Senior.
Here.
Member Alfred Swanson.
Here.
Member Laura Jacksack.
Here.
We have all members of the board present. Okay, so we've got two cases to be heard. These cases have been consolidated for the purposes of briefing as well as oral argument. However, if a decision is reached today, we will very quickly try to put the decision together and give it to everybody, but there will be two separate decisions because it's two separate cases. But for the purposes of oral argument and presentation of the motions, the cases will be consolidated. So at this time, we're going to call both cases 25 MOEB01 and 25 MOEB02, Dempsey versus Broadview's People's Party, and Patterson versus Broadview's People's Party. Objectors, can you please state and spell your name for the record, and please use the microphone. Hold on, please use the microphone so that the public could hear it, as well as the court reporter. Thank you.
Princess Dempsey, that's Princess. Dempsey is DEMPSEY. Objector?
Angela Patterson, ANGELA, Patterson, PATTERSON. Objector.
Thank you.
Thank you.
Matthew Welch, WELCH, on behalf of the candidates.
Okay, thank you. And last time we were here, we did set a briefing schedule. All parties filed the briefs in accordance with the briefing schedule. And Mr. Welch, you had moved. You were the one that made the original motion to strike and dismiss. So it is your turn for oral argument.
Sure, as I stated in the initial hearing, there were essentially three bases which the objector attempts to invalidate my client's nominating petitions. One has been withdrawn. The two remaining relate to, first, the allegation that their party is a established political party as opposed to a new political party. This is based on Section 10-2 of the Illinois Election Code. I believe that the objector's arguments are based on a misreading of the statute. They believe because the Broadview People's Party has appeared on the ballot at some time in the past, they are a established political party. As I tried to lay out in the motion, the only relevant question is, were they a party that received a sufficient number of votes at the 2023 consolidated election? And we attached to our motion the certified results from the Cook County Clerk's Office, which established that in the 2023 election, that the only party that appeared on the ballot was the Broadview Progressive Party. The Broadview People's Party did not appear on the ballot, let alone did it receive 5% of the total vote that was cast. So on that basis, we believe that this objection should be dismissed because the Broadview People's Party is not an established political party. In the reply, we cited Foster v. Municipal Officers Electoral Board for the principle that in the event an established political party fails to run any candidates in a municipal election, it ceases to be an established party within that municipality. When the Broadview People's Party, even though they received in excess of 5% in the 2021 consolidated election, when they didn't receive that 5% threshold in 23 and didn't run anyone in 23, they ceased to be an established political party, and therefore we correctly filed as a new political party for this 2025 consolidated election. The second remaining issue, they allege that there is some conflict between the Broadview People's Party's nomination petitions and a D1 statement of organization that was filed with the Illinois State Board of Elections related to the party. in their objection as well as their response, they failed to cite any legal authority that ties D1s and nominating papers together. There's no obligation that they're supposed to match. They deal with two completely different issues. One is to appear on the ballot and be a candidate. The other is to raise money. If the Political Action Committee is raising money to support someone who's on the ballot but not on the D1, that's a campaign finance issue, not a ballot access issue. Again, because the objectors failed to cite any authority in support of their position on this D1 matter, we believe this issue should also be stricken. In effect, because of the three, one was waived, and the two other matters should be dismissed on the legal bases I just stated. I believe the objector's petition in its entirety should be stricken with prejudice.
Thank you very much. Ms. Dempsey and Ms. Patterson, will both of you be responding separately, or?
Yes,
Okay, so you're going to make statements, and then Ms. Patterson's going to make some statements?
I think so, yes.
Okay, all right. Would you like to go first, Ms. Dempsey?
Absolutely.
Okay, thank you.
The attorney stated that a couple of things. The objector, the Broadview People's Party has been established since 11/30/2016. The party filed a statement of nomination papers, which is insufficient, saying new political party, which is fooling the voters. Which will make the nomination papers invalid. The Broadview People's Party has also ran. He stated that it makes them a new party. So every time they run, is it a new party? They ran in 2021 and 2017 as Broadview People's Party. They ran in 2021 as Broadview's People's Party. So they did not file a new political position. The nomination papers says new political position. The reason why I asked about the D1 statements is because on the D1s, when you pull it, it's either going to say new political party, but this one says amended party. It does not state that it's a new party. It said it's amended, meaning that the Broadview People's Party has also been collecting funds on this. According to the Illinois State Board Candidates Guides, it says a new party shall not bear the same name or include any established party. That's 10 IOS 510 10.2 10.5, and that's an Illinois State Board of Elections. I also put in evidence that to show that it says new political party, which makes the petition invalid, because they're not a new party. They have been established since 2017, and even if they were a new party, they didn't change their names. And according to the candidate state guidelines, it says that a new party, you cannot use the same name. And that's also 10 LIS 5710.2, which is also in Illinois state law that states that. So this would invalidate petitions. I gave copies of the results of the D1s. Like I said, the D1s was just a sample of saying that they did not establish, it didn't say new, it said amended. And I was using that as an example that there was not a new party. And they have ran several times under that name. So my question to the board is, every time they run, they become a new party and they keep the same name, but it makes the nomination papers invalid as a whole. And so his motion to dismiss should be stricken, because, like I said, they are an established party. And even at one time in his motion, he states they're an established party and not a new party. So that's just my argument there. Thank you.
Ms. Patterson, is there anything that you would like to add to that? Or are you adopting the arguments presented by Ms. Dempsey?
My statements,
Thank you.
my statement is pretty much the same. You know, as being a new candidate and being a new political party, that the paperwork that they submitted did state new political party, and as stated by their attorney in his documentation, it's new political party. And if we can complete, make documents, they should state exactly what they are. As a new candidate coming in, I know that's a horrible mistake for me to make, so I would assume that anyone not following the candidacy guide would be under the same protocol, using whatever documents or forms that are stated by Illinois and Cook County when filing documents for whether it's candidacy, petitions, and other legal documents. So That's it.
Okay, thank you.
Thank you.
Mr. Welch, you do get to give a reply to the statements of the objectors.
Sure. So the question is, what is a new political party under 10-2, an established political party under 10-2? Not necessarily what a lay person may interpret new political party to mean. The fact that Broadview People's Party ran in 2021 and 2017 is irrelevant under 10, well, it does not prove that it's a new political, an established political party under 10-2. The D1 Statement of Organization, Section 3, is checked as an amendment. They filed this on December 21st, 2020 to make an amendment to some of the information that was provided, that is being provided to the State Board of Elections. There's nothing that states that the Broadview People's Party must terminate its political action committee when it doesn't run someone in election, in a particular election. That's all that's going on here. It's the Broadview People's Party PAC has been in existence at all times, but it hasn't been, it is no longer an established political party when it failed to run people in the 2023 election.
Thank you. Do the board members have any questions or comments that they would like to make in relation to the arguments presented by the Candidates Council and the objectors?
I have a question,
Yes, please go ahead.
and this is really for both parties. So in the document is essentially the response, but it's titled "The Motion to Deny the Strike and Dismiss of the Respondent's Petition." And on page 2, it says Broadview People's Party ran in 2017 and 2023 under that name. And I just wasn't sure, and then we have the trustee election in 2023 in Broadview. And I'm not from Broadview, so I'm not super familiar with what was on the ballot.
2021.
Okay, so I just want that to be clear. So everyone agrees that Broadview people, the party at issue here, ran in 2021 and 2017.
Correct. 2023 was a whole nother party, yes.
Okay, so it's, everybody agrees that the Broadview party at issue, Broadview People's Party, did not run in 2023.
That is correct.
Okay, thank you.
Does anybody else have any other questions on the board? Pardon me. Okay, so at this time, I'm just kind of going to go over as the Electoral Board Attorney what my understanding of the law is. And if the board agrees, obviously the board can take whatever vote it wants, whether to sustain or overrule the objection. Most election attorneys know, and most people practicing in this field and more experienced in this field, do know that to be an established political party, you have to field candidates, you have to put candidates up for election basically every single cycle. And when you have a local established political party, such as the Broadview People Party or the Broadview Progressive Party or the Broadview Fun Party or whatever sort of party you want to call it, if you create a new political party in one cycle and you don't run candidates in that next cycle, the case law specifically shows us, as well as the actual verbiage of the statute itself, show us that when an established political party fails to run any candidates in a municipal election, it ceases to be an established political party within that municipality. And that's from the Foster versus Municipal Officers Electoral Board case. Citation 113, ILAP 3rd, 721. So it is my recommendation, based upon the law and what has been presented to the board, that the objector's petition as it relates to that specific issue be overruled. Then as it relates to the D1 issue, I'm not quite sure if the objectors were using that as sort of a demonstrative exhibit, if you will, that they were trying to demonstrate that they believe that there is a violation of the new political party items that we were just speaking of. But regardless, what happens on the D1 has absolutely no bearing on election petitions. That is, number one, a completely separate section of the election code. There is nothing in that article of the election code aside from ballot forfeiture that would affect somebody's ballot access. And for those that don't know, ballot forfeiture basically means if you owe a debt to the State Board of Elections and you haven't paid your debt, the State Board of Elections can say you are no longer allowed to be on the ballot. So that's what ballot forfeiture is. So it also is my recommendation that the objections related to the D1 also be overruled. Does the board have any questions based upon my recommendations?
Nope.
Okay, is the board ready to make a motion and take a vote?
Well, I think just in the interest of deliberation, I think that, just want to be really clear on the record that, yes, a party, once it runs candidates, it has to not just run every election, but it has to, what it does in one election, it has to earn 5% of the vote to be able to be an established party for the next election, and otherwise, that party loses its established, it's no longer an established party, it loses that special prerogative and has to go through all the effort of establishing itself as a new political party if it ever wants to run again. So that seems to me to be what happened here, and it could happen if it ran, it could have happened also even if it had run in 2023 and just failed to get 5% of the vote. Then it wouldn't have, wouldn't have achieved the status of being an established party for the next time. So it sort of goes from one time to the next, rather than just sort of if someone had reached 5% many years ago, even if those people still used their name in public and in other ways casually, but if they didn't, if the voters didn't make them an established party by voting 5% or more, they wouldn't, that group party wouldn't be an established party for purposes of ballot access in the next election.
To amplify on that, as I understand the law and the statute and the Foster case, you could have Party A could run candidates in 2015, 2017, 2019, 2021, and garner more than 5% of the votes in that, it would be an established party. But if it did not do that in 2023, that status as an established party ceases, and it has to start over if it wants to run again. That's my understanding.
That's also my understanding of the law.
Yeah, the law can be tricky.
It can be. That's why we all are here. Member Senior, do you have any questions or comments, or do you agree with the representations or statements made by your other two board members?
I agree with the representation of what they said.
Okay. Is there anything else that the board would like to offer by way of deliberations?
No, I think I agree with our counsel that the D1 falls under Article 9, and that's campaign finance law, and so similarly, you can't get around, you have to have voters have to vote for you 5% or more to be an established party. You can't make yourself be an established party or keep an established party just by keeping your PAC going. That's not enough. It has to be only the voters can keep you an established party.
Thank you. Okay, well, at this time, is the board ready to take a vote on whether to sustain or overrule the objection?
I think we still have the motion to dismiss pending, though.
Oh, that's true. I'm sorry. Yes, so we do need a vote on the motion to dismiss. Would anybody like to make a motion to either deny or grant the motion to dismiss?
I'll make the motion that we grant the motion to dismiss the objector's petition and apply that motion to both cases, 2025 MOEB 01 and 02. Or do you need separate motions for those two separate cases?
Let's do separate motions just for the sake of creating a clean record.
Then for the case of 2025 MOEB 01, I move that we grant the motion to strike and dismiss.
I'll second.
Okay, so we have a motion by Member Swanson and a second by Member Jacksack to grant the motion to strike and dismiss. I will do a roll call at this time. Chair Senior.
Yes.
Member Swanson.
Yes.
Member Jacksack.
Yes.
Motion carries. And so because the motion to strike and dismiss has now been granted, the candidate's name as it relates to 25 MOEB 01, the candidate's names shall be printed on the ballot.
And we have 5 days for judicial, correct?
Yeah, we'll go over that at the end. Okay, and for 25 MOEB 02, do we have any sort of motion related to the motion to strike and dismiss.
I'll move that we grant the motion to strike and dismiss the objector's petition.
I'll second.
Okay, so we have a motion by Member Swanson to grant the motion to strike and dismiss, and a second by Member Jacksack. I will now call the roll. Chair Senior,
Yes.
Member Swanson,
Yes?
Member Jacksack.
Yes.
Okay, thank you. So our office has taken the liberty of starting a written decision. It was not completed because obviously didn't know how the board was going to vote. So if it's okay with everybody, I can take about 15 minutes and go in the back room, finalize the decision. Then at that time, we will come out here, deliver written copies of the decision. And once we deliver written copies of the signed decision, what that does is that does start that 5-day time clock for appeal. So keep that in mind. So we will do a short recess for about 15 minutes. So can I get a quick motion to recess for 15 minutes?
Second.
All in favor?
Aye.
Aye.
Motion carries. All right, we'll be in recess for 15 minutes, and the time is now 4:25 PM. 5:14 according to the satellite. That clock's wrong. No, it just turned 5:15. So the time is now 5:15. We are reconvening this electoral board. Can I get a quick motion to reopen the electoral board meeting?
I move we reconvene 5:15 PM.
Second.
All in favor?
Aye.
All right, motion carries. We are reconvened. At this time, we have issued, or the board previously voted to dismiss, or to grant the motion to strike and dismiss. And so at this time, we do have a final decision, and the board will now sign the decision. They have reviewed the decision, made their appropriate edits to the decision, and we are now ready to sign the decision. And so the first decision that's going to be signed is in case 25 MOEB01, and then the second decision will be 25 MOEB02.
I know.
You want to date it, too? Oh, I didn't sign the was there a certification on that one? I didn't sign that.
What?
I didn't sign the certification on that.
Oh, pass that one
And
back
nobody else
over.
signed the front page on this one.
Oh, yeah, let me see the back certification.
What page we have to sign?
There's 2 pages to sign.
No, right there. Sorry. I should have pointed that out, my bad.
Why 2 pages?
Because there's a certification, Tiffany, our council, is doing belt and suspenders. We're doing extra careful.
Yep. That was a good catch.
Mm-hmm.
Wow. Mm-hmm.
That's O2, right? So it needs to go the other way, though. I already signed it, didn't I? We need to flip them. Which way we're going.
Okay.
That one goes back to me, and this one
Oh,
goes to you.
okay. I'm like, okay.
Yep.
Okay. I think that should be it.
All right.
Yep.
Okay.
Making sure. Yep, okay.
Okay, great. We are now giving the copy, or the original signed decision over to have copies made, so if you just wait one moment. Board members, do you want copies for your records?
I do.
Okay, so 1, 2, 3, 4, 5, 6, let's make 8 copies. That way there's extras, just in case. No, because we got to deliver the decision in open session, get them to acknowledge receipt, so.
Okay.
I thought about that too, though. At this time, we are going to tender the written decisions in open session. And just for the record, the date is December 10th, and the time is 5:24 PM. Ms. Dempsey and Ms. Patterson, would you mind coming up and acknowledging receipt of the decisions? That is yours. Okay, can you do it in the microphone, too? I apologize. Here, if you want to do it.
I received the decision, thank you.
Hi, this decision has been received.
Okay, thank you. And Mr. McGreer, we also, you are going to receive a copy of the decision on behalf of the candidates as the attorney has left for you guys?
That is correct.
Okay.
And for the record, I will receive Kevin McGreer, Kevin, McGreer, McGreer.
Okay, great, thank you. So the decision has been tendered in open session to all parties. All parties are in receipt in their hands of the decision, and there being no further business before this board, before we adjourn, we do have to call for public comment. Is there any public comment? Okay, there being no public comment, I would suggest that we do a motion to adjourn this board, and I would like to thank the public members as well as member of Andrea Senior for attendance at these hearings.
Our work having been completed, it now is 5:26 PM. I move we adjourn.
Second?
All in favor?
Aye.
Aye.
None, motion carries. Meeting is adjourned at 5:26 PM.